Well, this afternoon, Special Prosecutor Kisi Ejabeng is firing some salvos at High Court Justice Ifeasewa Asare Botwe. The anti-graft officer says the judge totally misapprehended his application for confirmation of the freezing order on the will of former Chief Executive Officer of the Forestry Commission, Kojo Owusu-Efriye, popularly known as Sir John. Mr. Ejabeng froze the assets of Sir John as part of investigations the office commenced into the acquisition of some state lands and properties that were contained in Sir John's will. In May this year, it emerged that the will of Sir John contained some parcels of land at the Achimota Forest Reserve and the Sakumono Ramsar site. It also contained some 4 parcels of land in the Achimota Forest, which the late politician gifted to some individuals, quote, forever. Well, court correspondent Joseph Akable has been monitoring developments for us, joins us now via Zoom. First of all, Joseph, help us understand what transpired in court today and the grounds on which the justice had to throw out the application by the special prosecutor. We'll get Joseph Akable for you shortly, but let's bring you the statement that we're receiving through from the special prosecutor, which says that he's directed the filing of an appeal against the ruling. He explains why, and excerpts of that on your screens right now, and I read portions of it for you. First of all, indicating that the net effect of the ruling of the High Court is that a person in his lifetime gleefully acquire property through corruption and then upon his demise happily pass on the corruptly acquired property to his beneficiaries for their benefit, and by doing so extinguish all scrutiny as the propriety or otherwise of the acquisition of the property because of his corrupt activities were not discovered during his lifetime. Now, the special prosecutor continues to say that if this decision is left to stand, the Republic will lose the fight against corruption in unimaginable ways. The investigation into the estate of Kojo Owusu-Efriye alias Sir John will still proceed. So portions of the statement there coming through from the special prosecutor. Let's get more from Joseph Akable, who was in court today. Joins us with details of the grounds on which the justice of the High Court then had to throw out the decision or the application from the special prosecutor. But we can just bring you a bit more of the details of what it is that the special prosecutor has been talking about in his statement. Also detailing and giving a rundown of how activities started. So what we know is that on May 30, 2022, the special prosecutor directed the freezing of the estate of Kojo Owusu-Efriye alias John, the former Chief Executive Officer of the Forestry Commission. Then on June 9, 2022, the special prosecutor applied to the High Court for a confirmation of the freezing order. Now, July 12, 2022, what we do know is that the High Court then, presided over by her ladyship, Justice Ifeasewa Asare Botwe, inexplicably dismissed the application as the statement from the special prosecutor is indicating to us. Now, the judge, according to the special prosecutor, and this is where they express their view, that with respect, totally misapprehended the application for the confirmation of the freezing order and misdirected herself by characterizing the application as that of a confiscation order, which regimes are governed by some different considerations. So that's the position of the special prosecutor on the matter, going on to say that the regime for an application of confirmation of a freezing order is designed to actually facilitate an investigation or prosecution to avoid dissipation of the property in question. Now, while a confiscation order is designed to permanently deprive the owner of the property, the special prosecutor then is now asking that investigations be taking into the circumstances of the purported accusation by the deceased of some protected lands in the Achimota Forest Enclave and the Sakumono Ramsar site. And the statement goes on to point out some more activities that the office has been up to. But it's clear now that the special prosecutor wants to appeal this decision. Joseph Akable was in court today. He's been monitoring the developments on that. But Joseph, first give us the ground on which the justice is making this decision to throw out the appeal from the special prosecutor.
From a key disagreement between the Office of the Special Prosecutor and the lawyers for the estate of Sir John. It simply has to do with under which provision the SP should be acting under. I mean, the SP are taking the view that under Section 38 to 40 of the Office of Special Prosecutor Act, it empowers it to freeze assets of any individual that is being investigated if it finds that it is necessary for investigations to happen. And so this was the basis for the freezing order that was directed by the Special Prosecutor. The Special Prosecutor indeed notes that under the Act, if within 14 days you take the view that you want the assets to remain frozen, you have to apply to the High Court. And so it's on that basis that this application was sent to Justice Safia Saribotri, asking that she confirms the freezing order, which would have meant that the assets could not be moved, could not be, alienated by way of sale, could not be sold or any other thing. It would just be kept and remain while investigations continue. And so that was what was the position. But the court took the view that Section 54 rather is the appropriate way to come under. That has to do with confiscation. It's actually titled about properties that, are acquired in the event that the person who is said to have acquired it has died or the person absconds. And so the Special Prosecutor argued in court and took the view that that provision is not a relevant one because it has to do with a person who has been convicted or has been charged of an offense. And that is not where they are at this point in time. They are simply carrying out investigations and asking the court to confirm their freezing order because they think it's important for those assets to remain frozen while investigations continue. And so that was the agreement on both sides. But the court took the view that the Special Prosecutor, in terms of the request, does not meet the standards required for the court to grant the confirmation, and so proceeded to dismiss that particular application by the Office of the Special Prosecutor.
Let's understand this. Obviously, we know that the Special Prosecutor is also laying claim to some provisions within the law. What is he laying claim to, and why does he believe that he has the powers to go ahead and freeze the will of Sir John?
They insist that Section 38 to 40 of the Office of Special Prosecutor Act is the appropriate one that empowers them to do what they are doing, and that all they were simply asking the courts to do was to confirm the freezing order that the OSP had exercised its power to impose. And so they hold a view that this is not a situation where they are actually prosecuting someone or charged someone or have convicted someone. It's not a case that they are confiscation assets that they know for a fact to be tainted or to be process of crime. This is one that they are just carrying out investigations in line with their powers under Section 38 to 40. And so this is what the SP believes that is something that, if the decision of the court is allowed to stand, as far as they are concerned, they believe that it will be against the fight against corruption, in that once an individual acquires property not in accordance with due process and that person dies, it means that the property will simply pass on to whoever it has been ruled to, and the state will not have any hand or any legal basis to step in to try and do any recoveries if necessary.
Joseph Akable is our correspondent joining us with the latest on this. Let's get some legal perspective on this. Justice Abdullah is a law lecturer, the Law School, University of Professional Studies, Accra. Thank you, sir, for your time. So let's get into it. The Special Prosecutor believes that the Justice, first of all, misapprehended the appeal or that demand for the confirmation of a freeze on the will of Sir John. Very harsh words. We've not seen that from any of the special prosecutors that we've had, at least not from Martin Amidu, that we know to be very fiery. But of course, now this special prosecutor appears to be taking on even the bench, I should say. But what do you make of his opinion that the Justice did not really get the terms on which he was approaching the bench? Kindly unmute for me so I can get the point you're making, sir.
Sorry, I don't know whether you hear me now.
Yes.
Can you hear me, please?
I can hear you.
Thank you. So my point is that it will be very difficult for me to be able to make any pronouncement on the basis for describing the orders of the judge the way he did, without the benefit of the application and the full ruling before us. However, I can understand why he says so, because the provisions under Section 38 are quite explicit. If you go under Section 38, it's not as if you're going for a fresh order to freeze a particular property. There is already a frozen order in place, which the applicant only goes for a confirmation of. of. Now, but describing the judge the way he did, for me, is quite difficult because knowing, if you say, well, she's dealt with some of these matters severally, particularly under the Iyuko regime. This is what she's been doing on daily basis, almost on daily basis. Almost every case involving fraudulent transactions or involving Iyuko or other matters involving illicit funds appears to be in her court. And so, and if you can understand, because she sits in the financial court. And so she's dealt with some of these applications severally, I mean, with her several years at the High Court that I've known her. So these are not completely out of place for her. But she's simply telling us that she would not give her blessings to any freezing orders.
And that's why I want to get your expertise. Right, precisely. And that's why I want to get your expertise on the process of what the law says about the confirmation process. Is it the case that a justice, for instance, has discretionary power to approve or otherwise when we find ourselves in such a case?
Indeed. The judge has a discretion to exercise, and you would have to convince her to the limits that she believes is right. Of course, her discretion is exercised within the law. It's not exercised capriciously. Now, if you go through Section 38, you will notice that usually, once the special prosecutor considers that a particular property is desired property to be frozen, he has a right to freeze it. Now, after the freezing, if he intends going beyond the 14 days, the rules is that he goes for a confirmation. Now, let's remember this. This is not completely lost on all of us. When this order is refused, it doesn't stop the special prosecutor to further to exercise his right to freeze the particular property every now and then. He can always exercise this right. The affected party is the one who then would have to go and convince the court to defreeze his property. And so, as would always happen with our judicial system and indeed our criminal practices, there's no bar that simply on the basis of the judge refusing the application, he doesn't have a right to further freeze it for 14 days. So what it may mean is that almost every 14 days, he would have to renew his freezing order. I mean, on the literal angle. This can always happen. And this happens on daily basis with our practices. I may not endorse it. I'm not endorsing that. It's an abuse of the right, but this is what happens. And so you are likely to find the special prosecutor exercising this right to further freeze this property after the refusal of the application. And he may probably do so subsequently until there is a specified order ordering him to abstain from the freezing processes.
And I just wish we could bring back the concluding portions of his statement where he's talking about the implication, for instance, for the nation. His belief is that someone who illegally acquires, for instance, a property, and we're assuming, without admitting at this point, that he's referring to the late Sir John, his cause for concern is that in the lifetime of such a person, that person may gleefully acquire, and you have that on your screens now, acquire property through corruption, and then upon his demise, happily pass it on corruptly to his beneficiaries for their benefit, and by doing so, extinguish all scrutiny as to the propriety or otherwise of the acquisition of the property. So do you side with the special prosecutor when he expresses this fear that you could have a repetition of a similar case where people would acquire property unlawfully and then pass it on upon their demise?
Indeed, generally speaking, that may be accurate to put. Generally, you are likely to find these happening, and indeed, it's not limited to this scenario. We may, if you've noticed, with political appointment and political corruption, similar things happen. You find that public officers and other high-ranking officials who are involved in political or corruption and prosecuted for their offenses would always have what one may probably call a very generous punishment meted out to them, 2 years, 3 years imprisonment, and they return with finding their booty, of course, waiting for them. After 3 years, you come back and whatever you have been accused of, if indeed you did steal it, you find it waiting for you. If it is millions of dollars, you come and enjoy it. So it is not necessarily limited to passing it on after your death. This one is passing it on even during your lifetime, after your sentence. You come and meet your millions of dollars waiting for you. You have a better life, even more than those of us who are still working and struggling throughout the years that you were in custody. And so this is generally an accurate picture to paint in regards to our fight against corruption and graft. But as to whether this particular instance can be said to be one of such, I think it is yet to be pronounced upon by a court of competent jurisdiction. And so I may not be able to competently say that indeed Sir John's assets were corrupt, were obtained from corrupt practices or other unlawful conduct, for which reason I can attack the decision of the court.
And that seems to be the disposition of the special prosecutor. We'll leave that to his judgment. But finally, the instruction for an appeal, you feel that's likely to succeed?
Because it's a grey area, we haven't had any of such in the past. I think it is something that we should all be desirous of awaiting the decision from the Court of Appeal if it does come out, because it is going to shape the office of the special prosecutor and indeed the entire regime regarding this particular area. Because hitherto what you would find is that it ends at the High Court and nobody really takes steps to appeal it. And so it is something that all of us would be watching closely to learn from in case a decision, in case it is actually pursued and a decision from the Court of Appeal comes out. Whichever way it goes, it would inform all of us as to the way forward in the fight against corruption in future. And so it is not something that we should be waiting for or praying for one party to lose or to win. I think it goes whichever way it goes for all of us, and it becomes a learning curve for all of us in the pursuit of justice.
All right then. Grateful for your time, Lawyer Abdullahi, this afternoon on The Pulse.